Hello, Ethan Vessels, lawyer practicing in Marietta, Ohio. I am licensed both in Ohio and West Virginia. Today's question is, how much is the fair compensation for my case? Put differently, how much is my case worth? The easy answer to that and the ultimate answer to that is always, what would a judge or jury award in your particular case? Now that is an unsatisfying answer because that still does not answer what your case is worth without knowing what a judge or jury would award. We'll come back to that in a few minutes. But the easiest thing to do, and what we must do in every case, is break the injury down into particular categories. The first category is medical bills. Now, assuming that the defendant is fully at fault, the law is that a person who is injured because of the fault of another is entitled to have his or her medical bills paid in full because of the injury. Now, that's not unlimited. First, it is the medical bills that were caused by the injury complained of in this case. So, a plaintiff cannot claim medical bills that are unrelated. And furthermore, it is the reasonable medical bills. For instance, if you fall down in a grocery store and the grocery store admits they are at fault, and you sprain your ankle, nothing is broken, but nonetheless you get 8 MRIs and claim $85,000 of medical bills related to your sprained ankle. The grocery store is likely to claim that your claim for medical bills is unreasonable, and you would likely not recover that. Next category of damages would be lost wages. If you are hurt and then you're not able to go to work and you lose wages, the law is that you are entitled to recover your lost wages, assuming again that the defendant is fully at fault. Now again, this is based off of the test of reasonableness. Again, if you fall in a grocery store and sprain your ankle and proceed to take 6 months off of work and claim $45,000 of damages, the grocery store, even if they accept that they are at fault, are likely to claim that you are making an unreasonable claim for lost wages. Third area of damages. This is what we call the general damages. Pain and suffering. Inability to do things that you could do before. And this is the most confusing, and this is the area where people do not know how much to ask for in their particular case. And the reason is, on the area of general damages, is that the law does not provide any guidance to juries or judges on how much to award in any particular case. Now, in some states, such as Ohio, there's a cap on how much a jury can award in most cases. However, in most cases, this does not come into play because that's reserved for the very serious injuries. Let's talk about pain and suffering. Many injuries will entail pain. You're rear-ended, you have whiplash. Your neck is sore, you have headaches for a number of weeks. That's painful. The law is that a jury is supposed to award the injured person a reasonable amount of money to compensate them for the pain and suffering that they have incurred because of the accident. Likewise, inability to do things that you could do before the accident. Some injuries will make it so that the injured person cannot do the things that they could do before, such as working around the house or doing things that they like to do, such as their Thursday night bowling league, going fly fishing, anything that they would have liked to do that they now cannot do. The law says that those people who are injured that way are entitled to an amount of reasonable compensation. Now, in gauging how much to award for pain and suffering or the inability to do things that you could do before, a jury will almost always take into account, is the injury temporary or is the injury permanent? If you are rear-ended and your neck hurts and you have headaches and this lasts for 8 to 12 weeks, you will not get a pain and suffering award the same as someone who is rear-ended at a high rate of speed, let's say, and suffers a herniated disc that bulges on a nerve that causes permanent pain and suffering for the rest of their life. The permanency of the injury can greatly affect the amount of money that a jury would eventually award for pain and suffering. Still, you ask, how do I know how much a jury would eventually award in my particular case? What I do as a lawyer that regularly practices in personal injury matters is that I consult what are called jury verdict research manuals. There are companies comprised of lawyers and actuaries who scan nationwide for jury verdicts on specific injuries. So the encyclopedia contains nothing but statistical information about what juries have awarded on injuries on particular parts of the body. For instance, if you have a broken arm, you can consult the manual to see what juries have awarded on other cases in which people have broken their arms. This will assist you or your lawyer in identifying what the reasonable range would be in a case with a broken arm. Now, there are always factors involved, such as how much are the total medical bills. Was it a compound fracture? Was it a simple fracture? Was work missed and were there lost wages? All of these things must be taken into account, but certainly the jury verdict research manuals can help you identify a reasonable range, particularly when it comes to the amount for pain and suffering. I hope this has helped you identify how to value your personal injury case. If you have other questions about personal injury matters, you can write to us or call us or visit our website and obtain a free copy of the book that I have written called I Have Been Injured, What Are My Legal Rights? We will send a copy of the book to you the next day free of charge.